Today, we're visiting the iconic Esquire Tavern. Officially opening in 1933 to mark the end of Prohibition, it quickly became a beloved fixture on the San Antonio Riverwalk. Home to the longest wooden bar in Texas upstairs and a more intimate speakeasy downstairs, the Esquire provides an uncomplicated, intimate riverside lounge and hangout. This bar has been here forever. I cannot imagine how much the criminal landscape has changed in that time period.
Would bear no resemblance to what the law was like when this bar was originally founded. And of course, it's been through different variations.
Right.
Different crowds have been passing through it over the years.
I mean, now, 98% of cases are pled out?
Something like that, pretty much.
That was certainly not the original, the original intent, the original framework that the criminal justice system was built on.
The Texas structure was designed to give you just enough delay to bring you from wherever rural backwater you were arrested in to the county seat. And then you got 10 days to prepare.
And no innate access to discovery necessarily.
The rules of evidence were considered to be a discovery tool.
That's right. Why do you think that is?
Cases are more complex, for one, but by and large, the real big change seems to be that plea bargaining has taken over everything.
I guess with the range of penalties being so wide, right? We talk about first-degree felonies, 5 to 99 years, even second-degree felonies, or life. Second-degree felonies, 2 to 20. Third-degree felonies, 2 to 10. 10 years, that's a long time in jail. As a defendant, you're tasked with doing that analysis, right? That risk analysis. And you have to say, I don't know, man, I can't risk it. Even, I can't risk going to trial.
Sure. And in the federal system, it's just as bad. I mean, the guidelines theoretically provide some safety net from exorbitantly high sentences, but for a lot of these drug cases, the guideline sentences just takes your breath away. On a large number of drug conspiracy cases, life is the ceiling for the judge. So even if the guidelines say you should get 5 years, 10 years, 15 years, the judge could say, I'm going to deviate upwards.
I guess a lot of people probably don't have a great understanding or grasp of, what exactly the plea process entails. A lot of people, this is their first time getting in trouble ever, right? They receive a document, they're told to come to court at some point. They don't necessarily know, what an indictment is, what an information is, what the process looks like. All they know is that they're facing this penalty and this amount of jail time is the potential punishment.
And for a lot of people, the guilty plea is sort of dangled over their head like, a piece of bait. Like, oh, are you tired of coming to court all the time? Are you tired of telling your employer every 30 days that you have to take off another day or at least a morning to go and attend a routine docket call for your lawyer to say, well, they don't have the lab work back yet. We have to wait another 30 days. We'll see you next time. I mean, people get tired of that.
Right.
They can't economically sustain it. Their employers are sick of waiting around for an explanation. All the while, this specter of the possibility that they could solve their problems by just admitting their guilt sort of reminds me of 1984. In the end, you'll learn to love Big Brother.
Right. I mean, especially when the carrot's being dangled in front of people, just plea and you won't have to go to jail. You go to you'll get probation. You get deferred adjudication. This could result in a dismissal. Is that a trap?
Well, some of it's a trap and some of it isn't. We got to unpackage that. It's a trap for some people and not for others, even though it's the same outcome on paper.
Right. Some people are just not capable of doing probation or doing deferred adjudication.
And for some people, straight probation, taking a conviction but not going to prison works fine. If you're self-employed and you're not subject to any kind of federal or state licensure, you can largely run your life the same as before, then taking a straight probation plea may not be such a big deal. But if you're subject to any kind of professional licensing requirements, or if your employer has strict rules about it, or if your employer is worried about the liability of it, then taking that conviction on the nose, even though you avoid prison, well, good job. You're not going to prison. You're also not going to work tomorrow.
I mean, even deferred adjudication. So all right, defer to wait, adjudicate to judge. People don't really understand that. It's still part of the whole umbrella of the community supervision program, right? It's the other side of the coin from probation. Probation is a conviction, but you get to stay out of jail. Deferred adjudication is a promise to the state to stay out of trouble, and if you abide by these conditions, they'll dismiss your case. But the reality is it's still on your record, right? I mean, you can't really hide it. All these licensing boards and organizations can still see it, can still consider it. It's a judicial confession.
It's a judicial confession. You're going in front of a judge. The judge finds the evidence was sufficient to find you guilty. He just holds off entering that finding formally on the record and expects you to behave yourself on probation. And don't get me wrong, for a lot of people, a deferred is an extremely valuable tool. It's not technically a felony conviction for some purposes. It is subject to the possibility, at least in a lot of cases, to non-disclosure.
But how much is non-disclosure worth these days, right?
With the internet, it becomes a matter of diminishing return, probably.
I mean, there's 24, 25-ish, 26 at this point. I'm not even sure. Different agencies that are empowered by the government code to see behind the non-disclosure, and when they run the background check. So like banking institutions, teaching, medicine, almost all of those are going to be able to see right past the non-disclosure.
Any elevated position of trust,
Yeah.
the code is increasingly exempting them from the protections of the non-disclosure. Those employers can find it. It's a wishy-washy sort of a positive outcome.
Right.
I mean, for some people, it accomplishes the main goal. What do we always want to see? Number one, don't go to prison. Number two, don't take a conviction, especially for a felony. If those things can be satisfied and something better could happen, then great. Try to push for the better outcome.
Right.
But those are the first two bases that have to be covered for anybody if they're going to want to try and seriously avoid
The stigma, repercussion, right, exactly.
But even then, I mean, okay, it's not a conviction, except we know that for some purposes it is. You go get yourself an aggravated felony deferred in felony court in the state of Texas and have questionable immigration status, visa holders,
Right.
Even potentially legal permanent residents. Those deferreds are good enough for the Fifth Circuit in terms of how the federal immigration proceedings will result.
As a basis for deportation.
And that complicates it. You might have a plea offer that to a criminal lawyer looks like a great outcome, but when you consult with immigration counsel, they remind you that basically you might as well just go in there and say, plea him to a straight felony. We'll like the conviction on the nose. The effect would be the same to him.
In this day and age, are you really comfortable advising a non-citizen about criminal repercussions as far as immigration without consulting an immigration attorney?
No, if there is any kind of right to be here less than United States citizenship, you need to consult with an immigration attorney hand in glove with your criminal defense lawyer.
I mean, yeah, there's obviously some very simple, petty crime exceptions, but even then it's like you want to talk to an immigration attorney, you want to confirm that you fall into that exception, that there's not some weird reason that's going to pull you out of that exception, right? A year and a day, type thing. I would say the law has changed a lot since Esquire was built, and the longest bar in Texas took its name
In so many different ways.
Yeah.
The process is driving people to settlement, always. And there's, colloquially, a lot of talk and commentary about the idea of the trial tax. Try your luck. Let's see how that goes for you.
Right.
There could be serious repercussions on the back end. And your lawyer's got to kind of be watchful of that and make sure that if you are going to try and put them to their burden of proof and hold their feet to the fire and make them do their job, which I commend,
Right.
that you know the risks and that you do what you can on the back end to mitigate.
I mean, even then, how often have you been presented with an amazing suppression issue, right? And then been told that the plea offer is going to get yanked if you dare to raise this in front of the judge.
It happens more often than we like it to, and I think it's a shame. The idea that somebody could be penalized for trying to assert a constitutional right, complaining about an illegal search and seizure. In my opinion, there's no room for that kind of hard bargaining in the criminal justice system, but I'm obviously in the minority opinion on that.
With Heath, with Watkins, recent Court of Criminal Appeals cases, it seems to be at least some recognition that depending on the prosecutor, depending on the DA's office, exists a sizable amount of win at all cost mentality. And Heath, and I would say Heath and Watkins are direct responses to that in some way. Heath is a direct remedy to a failure to abide by 3914, which is, the Code of Criminal Procedure, your right to discovery as a defendant. So if the prosecutor's office isn't fulfilling their obligation to do their due diligence in their investigation, if they're not turning over Brady, if they're not turning over, or they're making a determination as to Brady, they say this is not material to your case.
Brady material would be material that's exculpatory,
Right.
or that could attack the credibility of a witness that's testifying against you, or mitigating something that might demonstrate that while you are guilty, you shouldn't be punished as harshly as someone else might be for the same crime. That kind of material, isn't contingent on state court rulings or state court statutes to enforce. You have a constitutional right under the federal Constitution to receive that kind of material from the prosecutors and from the police. They have a duty to retain that information if its character is apparent, and they have a duty to turn it over, even if they wouldn't have a duty to turn it over under state law. So it's this magical special category of material, which, some people may have and some people may not.
How often do we see a determination about that material being made by prosecutors? It's like, this evidence, I didn't find it to be relevant or material to your case, so I didn't give it to you. Isn't that the whole point of Watkins, the whole point of...
Well, that's right. I think that those cases are going to try and maybe tip the needle a little bit more towards the idea that a prosecutor, if in doubt about the materiality of that evidence for the defense, should err on the side of disclosure. I think a lot of prosecutors are starting to see that, but you can tell that there are channels within the general community of prosecutors in the state that are resentful.
Right.
But that's a requirement. It isn't all Darth Vader, right? I mean, part of the reason they're resentful is because that responsibility is a massive amount of work.
Oh, without a doubt.
And they're being asked to search for needles in a haystack sometimes. It isn't like I'm completely unsympathetic to the plight that they have trying to do that. But when the chips are down and we realize that that material did exist,
Yeah.
right? It's my hope that we'll apply that constitutional standard in a way that tends to err on the side of the defendant.
Yeah.
That's part of our function, is to insist that that be the way that courts see it. And
To grade the state's homework, right?
Right. But Watkins and Heath are sort of beyond that. I mean, there could be things that are discoverable that aren't Brady, that have nothing to do with mitigating your guilt, impeaching the witness, mitigating your punishment, that are relevant to your case.
Well,
they have
the
the
analysis that, I mean, I guess my thought is that they might lead to, something that is exculpatory or mitigated, right? And so,
well, that in one part, yeah, but I mean, the beauty of Watkins is that it's mostly a question of statutory interpretation. 3914, the Michael Morton Act, is named after a gentleman who was falsely accused and falsely convicted of a murder and exonerated, I think, 25 years after.
Yeah, 2015
in prison.
I believe it was the 90s.
2012, maybe.
Oh, yeah.
Was when he was exonerated.
The act passed in 2015. It was,
Yeah, exactly. Legislature was appalled that this could happen. They passed these protections. Some of the things that happened in the Morton case, I think, were beyond just basic discovery problems. They were Brady problems, right?
Intentionally withholding evidence.
Prosecutors were held to account for that. There have been some acute results of that case. The spirit of that law was to try and promote as much possible disclosure to the defense as possible.
Right.
And so now you're talking about, we have these lofty ideals, and those lofty ideals become a statutory enactment of the Texas legislature. And now we have flawed human beings on both sides trying to sift through all the mud and detritus of these very complicated lives that have resulted in criminal charges and come up with, okay, this is the relevant evidence that you read. And sometimes that doesn't happen because there's a mistake. Sometimes it doesn't happen because there's a personnel change. The police officer that investigated it moves to Florida or something.
Or like you have a situation like with the Alec Baldwin case where the evidence is tagged under a different cause number, right?
Exactly. That was a huge mistake in terms of law enforcement and evidence gathering that could have been avoided so easily, and it wasn't. But because it didn't get fixed in the beginning, it resulted in a massive sea change from what could have possibly occurred had the trial been allowed to continue.
Under Watkins, under Heath, these Court of Criminal Appeals cases we're citing, under 3914 and that allegation, I guess, and correct me if you think this is wrong, but my impression of how prosecution should occur is, I like to analogize it to blackjack, right? The house has a lot of advantages, but they play their cards face up. And if you can beat them, great. But if you can't, and the house wins, guys. We all know that. There's no need to hide evidence. There's no need to hide anything. In my impression, certainly work product, the experts are on their side, there are discussions. But even at some point, what if an expert is saying, no, you're wrong. You're wrong. You're talking to a prosecutor. You're wrong about the law. You're about the application of it here. You're trying to convict an innocent man. Is that Brady? Should that be turned over? They're private experts.
Oh yeah, there are all sorts of layers that might, in the absence of this constitutional requirement, justify withholding that, right? Privilege, work product privilege, those kinds of things. Those all sort of die at the feet of the constitutional right of the accused to get his Brady material.
I feel like a lot of the kind of the animosity or the confusion between these issues, between prosecutors and defense attorneys, we are charged with zealously defending our claim, right? The exact opposite of that isn't the prosecutor's job. Their job is to seek justice. So it's not a directly oppositional job. It's offset to some extent, and sometimes I feel like that gets lost.
Well, there's an old Supreme Court case where they famously said that a prosecutor is justified in striking hard blows, but he's not entitled to strike foul ones. And I think the question we have to face in the modern era, in our present day, is what happens when the entire structure of the criminal justice system is engineered to functionally strike a foul blow.
Right.
Because I'm really not that concerned overarchingly with whether individual prosecutors are committing grievable actions or violating their ethical responsibility or hiding the ball. Those things happen. What I'm more concerned about is that police departments are overworked, and a lot of times the significance of these things is not being picked up on the first, second, third pass. Then things get put on the conveyor belt and they get sent over to the prosecutor's office. And in a big metropolitan city, that prosecutor's office is handling thousands and thousands of cases a month. All that intake has to be handled by people. Oftentimes, that group of people are not able to really go down and doggedly pursue every potential avenue and lead for additional evidence. And so it all gets bundled up and delivered to the defense attorney when the charges are filed. There's a certain amount of complacency in the way that all these cases are treated. I mean, it's just cookie cutter, paint by the numbers type criminal investigation and prosecution. And that naturally means that a lot of evidence that could have been gathered is not being gathered.
Do you think that the main problem then is an over prosecution of cases? There's too many and not enough resources? Or,
That's one problem,
yeah,
for sure. We have never had as many criminal laws on the book as we do right now,
right?
Except next year, when the legislature meets, we will have more. That is a never-ending saga. And so, for every crime, there must be someone who's committed it, and all those people get put into the funnel, and it bottlenecks.
It's always interesting sitting back and looking at a case, and you're like, well, I'm glad they charged it this way instead of this way. They had so many different ways to charge this offense, and you're happy that they charged it in a manner that's more approachable to defendant, right? How do you really reconcile that the penal code to those issues? Can you at this point?
One person at a time is basically all we can do. We have to go through and look at the propriety of the charge and decide whether the evidence meets the elements, whether a jury could convict on that charge, whether there's a more specific charge that should be brought that maybe has a lesser punishment. We're now in the world of parallel theories of prosecution, not lesser included, that all arrive at the same outcome. You can be charged with murder, but you could also be charged with aggravated assault causing serious bodily injury with a domestic violence finding. And even though it's a death case, it's a homicide case,
yeah,
you've essentially eliminated the jury's need to consider the ultimate question in a murder case, which is the causative effect.
Right.
Did the actions of this defendant cause this person's death? Those are the things that strike me as being particularly unfair. The court once said each state is like a laboratory, and they can define crime however they want to. Now they're just playing games.
Do you think that the burden of proof has been so reduced that jurors are happy to split the baby? You give an example of the case where it's a homicide, charge, intentionally, knowingly, causing the death of somebody. And then in that same indictment, or that same jury charge, you go through the entire trial process. You end up with a situation where they could be convicted of a lesser included offense for an entirely separate, slightly lower level offense with still, a 20-year sentence at max, right? I guess ag assault's 20 years?
Manslaughter, ag assault.
Yeah, exactly.
Between the way that the media primes the pump for these people to be deemed guilty before they ever set foot in a courtroom, and I think maybe a shortening of attention spans as a consequence of social media and everything else. No, I worry.
I think you hit the nail on the head there, because I feel like jurors are very willing to approach the ultimate issue, right? If this is a murder case, they will decide that murder issue. But then it is almost impossible with the loosely applied nature of the rules of evidence, 404B evidence, showing bad character, previous bad character, that jurors are they're more willing to say, all right, they didn't prove the murder,
But he's guilty of something.
but he's guilty. Exactly, he's guilty of something. And then because of the way that we can charge these offenses ultimately, you're allowed to laundry list out all these lesser included.
But it cuts both ways, right? It could be a mercy sometimes that a lesser included is an option for somebody. A man murders his wife, but At the punishment phase of the trial, he can demonstrate that, it's a flagrante delicto situation or
heat of the moment,
some excited situation where the heat of passion's involved. And the law lets them bump that down, make it a manslaughter. That's a mercy for someone who
but
caught red-handed.
But wouldn't sure, the state can, but the defense attorney has the ability to ask for that too.
Exactly.
Right? And so I guess I'm talking about it more in the context of the state putting on a case, realizing it's not as strong, and then ladder listing all of the lesser includes, because they got to get something. And then you run into a situation where the jurors have heard all these bad acts about this guy, that might be relevant, that might not be relevant to these other lesser included offenses. They might, or relevant or not relevant to the ultimate issue. And they're put in a hard position where they have to split the baby. They're horse trading, right?
We hope that they're not horse trading, but we know that can happen from time to time. And
I think you have to go in with both eyes open and recognize that that's going to be in the toolkit of both sides. The ability to pull the plug essentially and say, well, fine, we're going to pursue a lesser included, and we're going to gun for that lesser included instead.
Right.
Maybe they'll convict of the greater, but our chips are now all placed on the line to get the lesser.
All of these potential pitfalls that a defendant might, encounter in the process of, litigating their case. At the end of the day, going to a group of 12 people, 6 people to decide this issue, it can be a flip of the coin. It makes sense why people would not want to risk it.
People plead guilty for all sorts of reasons, and that's a direct quote from a Court of Criminal Appeals decision where the judges basically have acknowledged some people plead guilty who didn't do it.
Right.
And that there might be other strategic reasons why the person elected to choose to plead guilty instead of risk their chances at trial. I think that's appalling. That should not be how a justice system operates. It seems the opposite of just. It nevertheless is a reality of life. A justice system should be both fair and compassionate. If they take you out back and torture you for hours before they finally put you to death, but you had a fair trial, that wouldn't be justice. The reason why we think about plea bargaining as a mitigating factor against these things is because underlying all of it, people worry that the system is not fair. And because it's not fair, they will not be treated with compassion. So they need to hedge their bets.
Yeah, I think that's probably accurate in it, but it's a pretty nuanced combination of factors, right? Unfortunately,
Well, like that drug case that you handled, a couple years ago, where the government was of the position that the guy was a major distributor and that he had been moving lots of cocaine. And you went through the wiretaps, and what do we see? 2-bit, low-level drug dealer.
Yeah, dealing out of his shoe on his front doorstep. Small $10, $20 amounts.
We could have thought about his quote-unquote guilt, right? Technically, somebody that low level probably isn't a conspirator of the big drug conspiracy anyway. Why quibble about that when ultimately we know that if we can convince the judge that he moved this amount of product instead of this giant amount of product.
Right, accused of kilos and he's moving grams.
Right. Then we accomplish the same effect as if we tried it to a jury, lost, and then had to convince the judge that our evidence was right.
I feel like the vast majority of federal cases that we handle, the issues that we really fight about are like scope of conspiracy issues. We know the feds, they are very good at their investigation, and the federal prosecutors are generally very experienced, they're very smart. But a lot of times the issue is them overreaching.
Overreach and overcharging.
Overcharging happens everywhere. I would say more in the state cases than federal, honestly. Very easy to charge a first-degree felony and sentence someone to 5 years, and have someone else charged with a first-degree felony that gets 50.
Look at how these two different groups of prosecutors approach something as nebulous as conspiracy law. In state court, I think I maybe have handled one, maybe 2 conspiracies in state court ever. Prosecutors just don't charge it. It's in the code. You could charge a state conspiracy.
Yeah, I think I've only handled one. It was a gang case.
Yeah. The rest of them, it's all federal.
Yeah.
And it's all these massive conspiracies. The feds can charge conspiracy every day of the week. If you told your grandmother that you were going to go sell drugs that day, and she goes, "Okay, sweetie," they probably charge your grandmother as a co-conspirator.
She made you lunch, and then that drags her into the...
advances the objective, right? A naked agreement without an act in furtherance is enough in federal court to get a conspiracy charge. So we fight about those scope of conspiracy issues. In their mind, if they can prove any conspiracy, well then by God, everyone that you socialize with is a potential co-conspirator.
Right. So especially in drug cases, you face these massive amounts, right? Because the entire group of the conspiracy is the conspiracy as a whole is moving these massive amounts. But the individual person, might have only, come into contact with a very small amount of it, or not be involved with other spokes of the conspiracy or other circles of the conspiracy, or however you want to draw it up.
And that gets into the problem of relevant conduct, right? I mean, the idea that maybe you only did one thing to involve yourself in it, but because of like this idea of Pinkerton liability, you could be on the hook for everything your co-conspirator did that was foreseeable to her. That could put you in a whole lot worse place than you thought you were getting into when you agreed to do the criminal act. And I don't think that that's well understood by people.
I mean, it parallels a lot of parties' issues in state cases, though, right? A lot of people get into something and, they're like, oh yeah, I was just tagging along.
The way that the U.S. attorneys will charge those cases speaks right back to this conversation we had about the trial tax. Sometimes they'll even put in the indictment that your exposure is estimated to be, 1 kilo.
Right.
Or, 2.5 kilos.
But the relevant conduct.
But you understand that, that would be sort of what you hope to lock in at the top if you were to plea, if you were to play ball with them. You go to trial, and they put on some cooperator's testimony, but you actually
15 kilos.
Right.
Yeah.
Or that you were aware that he was going to move.
A kilo a month for the last 3 years.
Yeah, exactly.
Yeah, no.
It could all of a sudden just run away from you. And that's what their banking you'll worry about.
It's a valid worry because the laws regarding relevant conduct is just so wide open and nebulous, right? That they can throw anything in there.
Feels that way. I mean, there are obviously some limitations on it, but it definitely errs more on the side of including conduct than excluding it.
It certainly feels that way, and I guess the problem would be that if you pled, generally you're waiving all your rights to contest the relevant conduct.
Oh yeah, no. I mean, if you plead guilty, you're giving up a ton.
Yeah.
I mean, in state court, it's a little bit easier because in state court, by default, absent some agreement to the contrary, anything that you raised by written motion and had ruled upon by the judge required in the plea.
Preserve any appealable. You're not waiving those rights. You're not giving those up.
In federal court, the procedure is much more nuanced. Either the U.S. attorney is going to have to agree to let you have a conditional appeal.
Yeah.
So you litigate that motion to suppress, you enter your plea of guilty, you get sentenced, but the government has agreed that you are entitled to proceed on that issue. Or you have to go through a very complicated procedure where you essentially waive your right to a jury trial, go before the judge for a trial, stipulate that you're guilty based on every element of the charged offense, get convicted, and by doing that, you can make the contention that you accepted responsibility, right, which is very important in guideline calculation.
That get your points off.
You get your 3 points off because you acknowledged your guilt, and you spared the government the full expense of having to fly in its witnesses and prove up the elements, and impanel a jury and have to compensate the jury for their day and feed them lunch and all the rest of that drama.
All
you
the fun
spared
stuff.
all that crud, but you still, because you didn't formally plea, you haven't waived your right to complain about the issue on appeal. That's a pretty involved procedure.
Getting back to more generic plea issues, is it surprising to you that, for instance, DWI, the legislature recently passed the law allowing you to get deferred adjudication on DWIs. The kind of trap, the hidden aspect of that is that it's available to be used as an enhancement for another DWI. So it's really, I mean, what are we really talking about there? It's not a conviction for DPS purposes. You're avoiding some fines. It's not
By
like
your suspension?
Yeah, your license might have been suspended.
Right, assuming you rated through the ALR, let's say fine.
Since that's it's totally an independent issue. But so you end up with a situation where, I guess you get to say you haven't been convicted of a crime on an application for an apartment.
Is that the actual legal effect of a deferred DWI? I mean, it's hard to say.
Right.
If it's enhanceable, in my mind, if it's enhanceable, that's a conviction.
Right.
That's what I call a conviction.
Right.
The legislature ought to be ashamed of itself for calling it deferred. If you don't want people to get a deferred, if you don't want people to be able to admit their guilt but avoid a true conviction for the crime,
And the consequences of that
then
conviction.
keep it the way it was. We didn't have deferred on DWI at all.
Right.
Forever before this. I mean, there was not a deferred option. And I think that what that's all about is Mothers Against Drunk Driving, the police unions, they're driving this issue. Because, I mean, let's just be real. DWI is a racket. it's a racketeering organization practically. It's a conspiracy between police departments, the prosecutor's offices, and most importantly, the biggest moneymaker for the county where the case is being brought, the probation department.
Right.
That's what this is all about.
I mean, what you're really talking about there is the amount of overtime that officers rack up doing DWI work and being on the DWI task force. And you're talking about the fees that defendants are required to pay.
Oh, they'll nickel and dime people to death on probation. Ignition interlock fees, classes, supervision.
Scram, ankle monitors, $300 a month, monitor, all that kind of stuff.
Yeah, that's right. And get them started while they're awaiting their trial, where they're still presumptively innocent.
Right.
Let's get them started on probation. And then we'll give them another 6 months to 2
years. Yeah, 18 months, right?
It's just shameful. And the deferred is just the latest and greatest of these shell games that are being done on that front.
I mean, look, there's certainly a place for deferred. Serious felony offenses. Deferred, will allow you to avoid that felony conviction for most purposes, right? But I mean, like we talk about it deferred in, family violence offenses. In San Antonio, Texas, family violence is a blight on the community. At least that's what you would learn to understand having, read the local paper. Deferred adjudication doesn't save you from the consequences of the collateral consequences of a family violence offense, right? I mean, a judge can take into consideration the facts and circumstances of the previous conviction, whether or not there was a affirmative finding made at that time. All right, and so we're talking about, you do deferred adjudication for a family violence offense. You complete it, your case is dismissed. An allegation is made against you at a later date, and then you are automatically enhanceable to a felony offense from a misdemeanor because the judge pulls up that paperwork and says, oh, you know what, I'm reading the police report from this previous offense that was dismissed, and I'm gonna find this as a family violence offense. I mean, it's
conceivably possible, right? I mean, assuming notice has been attended to in the indictment.
Right.
I think there'd be a few steps required to consummate that, but it's conceivable.
Yeah.
Yeah, I mean, another classic example of why deferred isn't what it is billed to be. So why does this all happen? It happens because the system wants it to.
Well, I mean, because they make a lot of money off it.
I mean, it's jaded to look at, but I think it's the truth. And I think more people need to examine that. And I think one of the big questions is, for a lot of these people, is a resolution that avoids the risk of jail time worth it? And especially in the misdemeanor context, I oftentimes just wonder if that's the truth or not.
I mean, a lot of times it's very hard to discuss or a client that wants to take that deferred or a DWI. You're saying, man, you're passing up your ability to contest the blood, the stop, the field sobriety test. Look, jurors are fickle. They're not well educated on the law. Anything can happen. Anyone can win. You can catch the prosecution hiding evidence. You can, something crazy can happen procedurally. Are you really willing to trade that chance away on what is functionally a conviction?
For what? For what? You can be on probation for 2 years?
Because people are scared of going to jail, right?
That's the bottom line. In a lot of cases, all said and done, when they consider how broke they're going to be at the end of their probation, and when they consider how onerous it all is, and considering, just to be frank, the willpower required to avoid any kind of flare-up, and to consider the fact that you're dealing with a probation officer who could be a good person, but who could also just as easily just be ruthless with you. Unforgiving and uncompromising, and you're going to have to suffer under that person's every whim for 2 years. Or you might end up with someone you really like and they get transferred to another department, and in the middle of probation, you end up with someone who's a complete jerk to you. You know what? Roll the dice. Let's see what happens. It's a misdemeanor offense. Your probability of getting seriously punished is probably not that awful unless you've got a pretty bad rap sheet behind you. Put the state to its burden. Test your proof.
On that note, another drink?
Let's do it. All right.